Please get ready for a dictation of a legal passage, number 33. 5 seconds. In the present case, the court is dealing with a controversy which involves the welfare of people at the village level. Raising the standard of nutrition, living of rural population through distribution of food grains is the duty for which the monetary support is owned by the state out of taxpayers' money and is thus a state largesse. The supply of food grains at the subsidized rates to alleviate poverty is a lofty object, but the same cannot be achieved unless there is decentralization of the primary functions of the third tier of governance at the grassroots level. An effective and prompt mechanism of redressal of grievances at the local level, coupled with legal service, is also a condition precedent to actualize the purpose of law. It cannot be doubted that the most transparent manner of practicing equality under Article 14 of the Constitution of India is either through a process of competition between equals or through the vote of majority by equals. Employment of fair price shop agents from amongst the local residents of the village is the basic rule. The rule of discretionary preference for certain categories of persons in terms of Section 12(2)(e) of the National Food Security Act 2013 is aimed to achieve consumer-friendly results through an individual or a juristic person. This provision includes participation of public bodies or public institutions such as cooperative societies, gram panchayats, or self-help groups, as well as the eligible local residents for a competitive service. The inclusion of public bodies, public institutions is not suggestive of any restriction. Rather, it expands the competitive horizon between the various categories of persons so as to achieve the target of distribution of food grains more effectively and competitively. The expansion of competition for effective and faultless service when tested within the scope of definition of a person defined under the Competition Act 2022 gives an idea as to how wide the connotation of a person in legal parlance can understandably be stretched. In the present case, however, it is restricted to an individual and public bodies, public institutions of the description mentioned under Section 12(2)(e) of the National Food Security Act 2013. Ousting an individual from the zone of eligibility for selection of an agent is fundamentally wrong, as no person has an existence without the presence of an individual. The exercise of the right embodied under Article 19(1)(c) of imaginary without the association of individuals, therefore, for any kind of employment or licensing by the state, an individual person cannot be ousted once he qualifies the prescribed criteria or the condition fixed under law. It is to be noted that the reservation for various categories of persons being applicable in the matter of allotment of fair price shops further lays emphasis on individual identity within the local limits of the village. The impugned government order, dated 7/7/2020, surprisingly brings altogether a novel identity to the self-help groups. Learned Counsel for the state has stated that any self-help group comprising of larger number of individuals belonging to scheduled caste would qualify the group as scheduled caste group for the purposes of implementation of reservation policy. This court may strike a note of caution that Article 19(1)(c) within its ambit does not empower the state to recognize the identity of a juristic person on the basis of any attributes of caste, creed, or religion. Any such association is an entity for the fulfillment of aims and objects enshrined in its articles of association and by laws. The welfare state, that is India, as an organizational structure under the Constitution of India, does not have any identity based on caste, creed, or religion. The sovereign recognition of our welfare state, that is Bharat, is territorial, and this position is well defined under Article 1 of the Constitution of India. Stop.